presentations. Now we have some time for a Q&A session, and it's an open forum. And would anyone like to start? Yeah. Maybe the two presentations were so blindingly clear that there is a yeah, Tom.
Tom Burke. Firstly, I think that the wording of the existing article in the Constitution implies that a widower cannot properly raise children, and that is insulting to very many men that have raised children to be good citizens. Thank you.
Okay, let's maybe harvest a few comments and questions, and before we go to our expert panel. Okay, well, let's go directly to our expert panel. Which of you would like to take this comment about the widowers?
I think everyone does agree that the wording is sexist, all right. The one case, though, where widowers, curiously that you make that point, the one case in which this did come up before the courts was the case that I mentioned of OG versus the Attorney General, where the state, as I explained earlier, discriminated in favour of widows when it came to the question of adoption and discriminated against widowers. And the state attempted to defend that on the basis that women were somehow more suited to the parenting role. But that was actually rejected by the High Court, who took the view that, men were equally well capable of parenting. And consequently, the High Court declared that particular provision of the adoption legislation to be unconstitutional. And rejected the attempt by the Attorney General to rely on the clause that we're considering today to justify the discriminatory situation. So the courts have rejected that sexist view of widowers.
Thank you. Yeah. Again, could we, everyone, as a general operating principle, when people ask for the floor, will you, and ask a question, would you introduce, say your name, please? Thank you. Yeah.
Morning, folks. My name is Chris Lyons. I did note that when Siobhan was actually talking, one of the provisions recommended for an update was that the text be updated to say parents. And I would have a question regarding the legal definition of a parent, because that probably won't be all inclusive of all carers, I suppose, because not necessarily does one have to be a parent to look after someone, as in the case of, I don't know, the Diaspora looking after a brother, looking after a sister, or an elderly sister, or even a gay parent who will probably have to look after an adopted child. So I would ask that when we're reviewing the text that we kind of dissociate from a person looking after someone in the home has to necessarily be a child of the other person. I quite like the Iona Institute's version of carers, so anybody who is in a home looking after someone who isn't a dependent in a kind of a care facility. So I just had a question around the legality of the termage that we're going to use, because it'll probably come up for constitutional review for that term, as in what constitutes a parent, and will we have to have another referendum for that to talk about opening up the legal coverage for those terms. So,
okay,
cool.
Thanks, Chris.
Thanks.
I mean, that's probably sounds to me like a fairly fundamental issue. So, Siobhan, would you want to deal with that?
Sure. Thank you for the question and comment. As currently drafted, the wording refers specifically to mothers. So, a plain reading of the constitutional text is that it refers specifically to mothers, although the courts have suggested that in terms of reading the Constitution in contemporary society, that we might try to interpret that more broadly, but that would be to try to remove the sexist constraints of the language that is currently used in the text. With regards to the different proposals for reform, the proposals brought by the submissions that we will hear from soon is that the one possibility would be that instead of referring specifically to parents, which would be an expansion beyond what we have now, it would be wider, recognise the roles of all parents. But it's argued that Article 41.2 should include a wider recognition of the role of carers for dependents. So not just parents, but others who would perform a very important caring role, for example, for the elderly perhaps, or for a dependent sibling, as you mentioned. So the various submissions that have been made by groups to the Constitutional Convention, including by the National Women's Council, by Quorum, would be that the reference to parents might be too restrictive, and that the potential value of Article 41.2 should be that it would recognise the importance of all the contributions made by carers for dependents, not just in a parenting role.
Okay, thanks, Siobhan. Amy, who's next? Sorry.
Hello, Jim Darcy. Siobhan referred to, in referring to Article 41.2 and the special place of women in the home, you referred to the separate spheres theory and the Samuel Smiles Victorian theory of separate spheres, which identified women with feeling and emotion and men with reason, rationality and business. And I think that in the modern day, I think that we'll all accept that that's outdated. So I would say as a first premise that this article must be looked at and must be revised. In addition, could I say that, as Marx said, not alone has the oppressed to free themselves, but they have to free the oppressor as well. That men need to be liberated from this article as well, and we need a greater balance. And could I just ask, as regards family law, has this article, as it is presently stated, does it confer any additional legal rights in relation to care and custody in family law cases at the present time? And if so, I think looking at it from the perspective of men, if men go into court in family law cases, starting off at a disadvantage based on this article, I think it is also imperative that in this modern age that be looked at and reassessed. Would you like to comment on that?
Thanks, Jim. Good. I saw Maureen at the same table wanted to ask a question, so maybe we'll take her as well.
Maureen O'Sullivan. Just in Gerry's paper, he was mentioning Judge Murray's contribution, and it was something in that that the judge said, it seems to me the Constitution implicitly recognises similarly the value of a man's contribution. Is it enough, constitutionally wise that implicit is enough? You know, does it have to be much more specific, that we can't just say, well, it's implicitly implied? And the other one, would you have any suggestions as to why no one has brought a case against the state about improving the financial support for mothers under that particular term of the Constitution? Thanks.
Okay, could we maybe, no, let's take the two, because these are two substantive questions. Let's take them first.
Thank you for those questions. And taking them in reverse order. In relation to what Judge Murray is arguing about extending the clause as it currently reads to cover men, I think he's being a bit ambitious, to be honest. I mean, there are various theories as to how you can go about interpreting the Constitution, and we do accept that words sometimes have shades of meaning that you know you can interpret words in more than one way. But maybe I'm just intuitively conservative on this. It seems to me mother is a mother, and no matter how hard I try, I can't see how the word mother could implicitly cover father or men. And I think if this clause is to be changed, the more acceptable way to change it is simply by way of referendum. So I'm not very convinced by Judge Murray's line of argument here. I think he's stretching the language beyond its limits. With regard to using the clause to try and improve financial support for mothers or indeed carers in the family, in the home generally, as I indicated earlier, again, I would be pessimistic about using this clause in the context of litigation, of going to the courts and inviting the courts to order the state to improve financial provision. For the two reasons that I gave. First of all, the text of the existing text is weak in the duty that it imposes on the state. It doesn't oblige the state to support women in the home. It obliges the state to endeavour to support women in the home. It's a weakened form or a weakened duty. And then secondly, as I said also, the Supreme Court have made it very clear that they don't consider the courts should have any role in making decisions that impact on the distribution of public resources, that the courts cannot identify constitutional rights that will require the state to spend public monies on a particular group. These decisions were made in the context of the educational needs of people with severe and profound learning difficulties, and in the context of the needs of children from dysfunctional families who required state support. They weren't made in this context, but the reasoning would, I think, equally apply here. So I don't see the clause as it stands as being of much support to potential litigants. And then the first question, the interesting point about family law and the impact of this clause on family law. I'm not a family lawyer, so put that on the record. First of all, when I looked again just at the second case, DT versus CT, the question was raising the point that perhaps men would be actually at a disadvantage in, say, divorce proceedings insofar as the clause refers to the position of women in the home, and to the extent to which the courts might take account of that clause, they might just offer additional support to wives in divorce proceedings. Funnily enough, in DT versus CT, both Judge Denham and Murray actually used the neutral term spouse, that they talked about having regard to the caring role carried out by a spouse, that in the context of divorce proceedings they would have regard to the caring role carried out by a spouse. But unquestionably, I think the position would be better if the clause wasn't gender specific and if it covered a broader range of caring. That's my own personal view.
Siobhan, do you want to comment?
Yep. Just first, with regards to the fact that this provision not only assigns specific roles and duties to women and mothers, it also implicitly does so with regards to men by not assigning those kinds of roles. So it constrains and confines both women and men in terms of a specific view of their roles and duties as carers, as parents within the home and more widely. So that is certainly the case. And just an interesting point in relation to Ireland is a party to the UN Convention on the Elimination of All Forms of Discrimination Against Women. And when Ireland signed up to that international treaty, it did enter an opt-out, specifically with regard to a provision of the convention that relates to equal treatment on custody and guardianship of children and equal treatment in all matters of family law. And that opt-out was specifically that Ireland does give preference to women over men in those kinds of disputes. So again, it reflected a stereotypical view of the distinct roles of women and men, and perhaps not an adequate recognition of the roles and duties of both women and men with regard to caring for children. So that opting out of the CEDAW Convention didn't specifically reference Article 41.2. But you can see the similarities there in terms of the reasoning. And the CEDAW committee, the UN Committee on Discrimination Against Women, has repeatedly expressed concern about this particular provision and argued that it should be gender neutral, that it should recognise the roles and duties of both women and men equally. With regards to why has one argument has been made that this provision could provide an important support for the roles of women and mothers who work full-time in the home and take on caring roles. But as Gerry said, the case law to date hasn't provided for that interpretation of the constitutional text, and the constitutional text is relatively weak in that it is endeavour only, but where arguments have been made in the Cathy Sinnott case, for example, that argument drawing on Article 41.2, an argument to try to that the state should have given Cathy Sinnott more support in her role as a full-time carer for her disabled son. The majority of the court rejected the view that Article 41.2 could support that kind of legal claim to compensation from the state. And we've seen that also in the LNL case on disputes with regards to the family home, and that it hasn't been given that kind of interpretation. So in the very few cases where it has been relied on, it hasn't been interpreted in that way by the courts. So one of the arguments for reforming Article 41.2 is that perhaps we need a stronger recognition of the roles of carers and the duty of the state to support those roles, that we don't have that in terms of the current wording.
Thank you, Siobhan. Over there, please.
Thank you, Stephen Agnew. And coming to subsection 2, and just following on from what you were saying there, Siobhan, and what Gerry has referenced. Gerry, you stated that the word endeavour weakens subsection 2, but then you further went on to say, well, the Supreme Court has also stated that the courts cannot compel the state to spend public money. I mean, I get the impression, Siobhan, that you're suggesting if we remove endeavour, it strengthens that clause and may go some way to doing that. And I'm just wondering, given the Supreme Court's ruling, is that likely to be the case, or is it still going to be the case that the Constitution can compel the state to spend? And just wondering, is it worth even debating the word endeavour for that reason?
Which of you?
Well, I think the point that's been made is that because it refers only to an obligation to endeavour, so it's kind of a progressive, take some steps or try to, it's not a strong obligation on the state, so shall ensure would be a much stronger, a clearer, explicit obligation on the state. So, but where you don't have that in the text of the Constitution, then obviously the courts are limited in terms of what kind of interpretation they can give to that. So, just the clear wording of the text at the moment is that it is a relatively weak obligation on the state. So, removing endeavour would impose a stronger obligation on the state. The courts in more recent times have been reluctant to give a recognition to what we would call socio-economic rights claims, because of course there are many obligations on the state to ensure, for example, a right to a fair trial, which imposes significant obligations on the state in terms of allocation of resources, but that isn't typically questioned. So there is a reluctance to engage in more depth with kind of rights claims that relate to a distribution of resources in some socioeconomic spheres, although any rights claim would necessarily do so. Yeah.
Do you want to add, Gerry?
I would agree with that analysis. I mean, you correctly pointed out that there are two problems here. One, the actual wording of this text, but then behind that again, a more general attitude of the courts, as Siobhan has indicated, a reluctance to protect socioeconomic rights. And the context in which the courts decided that point was in relation to a clause that we recently amended in relation to protecting children. Where it was a very straightforward duty on the state, where families were incapable of supporting their children, the state had a very clear duty to step in and protect them. And even though the duty was stated in what we might say forceful terms, the court still took the view that this did not entitle the courts to hand down decisions that would dictate to the Oireachtas and to the executive as to how public monies were to be spent. As I said, that related to children who were in need of secure accommodation because they had certain personality difficulties and their families were incapable of looking after them. The other context in which it arose was the context of, again, the state's quite clear duty to provide for free primary education. That is fairly straightforward. But again, this reluctance to get involved in protecting socioeconomic rights came to the fore in the Supreme Court decision. So, if you do remove the word endeavour from this clause, there's a second obstacle to be overcome.
Okay. Thank you. Any other question before we? Yeah.
Hi, Brona Farrell. If the Constitution has made a point that the stay-at-home parent is almost tantamount to society, why is there not more provision made for stay-at-home parents, carers, to a point where it could be almost like a career choice that comes along with the same benefits, the same, well, I suppose the same benefits really, that it is a career, it is a choice. There are people who decide they want to stay home for the betterment of their family or whatever. It's not that they have to, and they shouldn't be forced to, and nobody should be made feel that they have to stay at home. I think an awful lot of it as well has to go towards the thinking of stay-at-home parents, that, you know, if as a woman you go out to work, you're less of a parent, that you're not a nurturer. That isn't the case. If the structures were put in place and it was accepted that home is as much of a career as going out to work, and structures were put around it where maybe, like with Sweden, they cater for 50% of childcare costs, which allow people to go out to work, then they can build a proper structure around nurturing their family as well as working. The opportunity should be there for both. But unfortunately, the thinking in Ireland at the moment is that if you don't want to stay at home and mind your children, then there's something wrong with you as a female parent. So maybe the thinking and the structures around stay-at-home parents need to be added into the Constitution to take away that, I suppose, that detrimental view. And if the state acknowledged this and allowed for people who do stay at home to have some form of remuneration, then that would sort of even the playing field for both parents. It doesn't necessarily mean that fathers don't get the same benefit. They're as equally as important in the rearing of children.
Thanks, Verna. Okay, that's a big question now for you as we conclude our plenary session.
Thank you very much. I mean, I think that argument is reflected in many of the proposals for reform of Article 41.2 that would support retaining a version of Article 41.2 because it is viewed that it is an important recognition of the contributions, the invaluable contributions made by carers, including mothers and fathers. And that role should be specifically recognised and supported by the state. I think historically the presumption was that it was a role and a function and a duty of women and mothers, and that the role of caring for dependents would be undertaken by the family, and that the state did not need to step up to that role and didn't step up to that role. So it reflects different views on the relationship between the state and the family, I think, that you find not only in Ireland, but also, for example, in some other Mediterranean countries, where there would have been a reliance on the family to undertake those kinds of caring roles, and that you didn't have and you haven't had the same tradition of the state stepping in to support those roles and to develop social welfare systems that would support the roles of carers, including as parents within the home. So unlike the Nordic countries, for example, we haven't developed those kinds of extensive supports. And that, in terms of the various proposals for reform, I think the key argument that is being made is that there is a possibility to recapture the significance of care that is potentially pointed to by Article 41.2, but at the moment is very limited and refers only to the roles and duties of women. But that could be broadened out to make an important statement about what kind of supports the state might provide to carers.
Gerry, would you like to make any comment on that?
No, I mean, I suppose the reason why there isn't more support at the present is entirely a political one with small p, you know, that the political system has, for whatever reason, chosen not to invest more money in relation to providing this sort of support. It's not a constitutional issue as such. It's an issue to be addressed to politicians rather than to constitutional lawyers.
Okay, we'll draw this particular session to a close. I do want to thank both Siobhan and Gerry for admirably clear presentations initially and for very clear responses to the questions. We're now